so what I'm going to do is talk briefly about these sort of the historic competition approach to these cases, and then, how that has created, if you like, some of the background, along with a number of the reports we've seen in the last 18 months to 21 months that provide, if you like, the impetus or the history, the backstory for the regulatory measures that are currently being proposed. So with that sort of roadmap, the first thing I want to talk about is, what is data? What is big data? Because if you look at the cases, there's, a fairly broad range of things. We're not just talking about personal data here. In fact, many cases we're not talking about personal data. And it's used by, a broad range of industries. The GAFA or GAFAM or whichever of those acronyms you prefer to use, are, if you like, the current focus of this. But if you look at and think about the way data has been used historically, you've got, FMCG, so fast-moving consumer goods, the old supermarket loyalty cards. They've been around for far, far longer. Think about the travel sector with your frequent flyer points. If you can remember back to when you were able to actually fly somewhere, your frequent flyer points, etc. Those kind of data collection exercises have been going on for 20, 30 longer years. And then probably in terms of scale, something that I think gets a lot less attention than things like advertising, which is something Paola's going to talk to later. It's also important to realize that the scale, if you like, of data collection in the context of things like e-medicine and fitness services, etc., is also significant and substantial. And that, I think, is part of the backstory, at least for what's happening at the moment with the very close scrutiny of Google Fitbit. But it's also important to appreciate this point about, but let's look at the actual data in issue. So you've got the online advertising cases, and we've had a whole series of those. They started with Microsoft, Skype, and thereafter, where the agencies, or actually even earlier, go back to the mobile wallet case, where the agencies have looked at the collection of data that has been used for advertising. And even back in the days of the e-wallet case, the Commission's conclusion was, okay, yes, this is a data set that can be used for online advertising, but there are a whole series of other data sets out there. And in fact, you can buy from third-party vendors data that can be used for the same purpose. So there's sort of that type of data set on the one hand, but then you have ones that are much more specific and much more difficult to replicate. So, for example, we've got the Reuters Instrument Code case, the Market ISDA, both of which related to financial services related data. In the RICS case, it was the four-letter codes that we use on the stock exchange to identify a company. And in Market ISDA, it was basically over-the-counter bilateral trades, where the only people who knew the price of the contract were the parties to the contract, and therefore anyone trying to come up with a derivative index needed to have access to those numbers. In both of those cases, they were both settlements, they were behavioral cases from the Commission, but they both looked at the fact that the particular data sets in issue were unreplicable. You simply could not work around them. If you did not have a license, for example, to use the RICS codes, you cannot take information coming off a stock exchange and usefully do something with it without a license to at least translate it to another form of identifier. The Sanofi Verily Life Sciences was the first of the cases that dealt with this idea of e-medicine, those types of health data and the sheer volume of data that could be accumulated. Just very quickly, that case was essentially about the idea of a joint venture to work with diabetics, and the idea of effectively implanting, hypothetically, continuous glucose monitors under your skin, the idea of perhaps producing, very, very small miniaturized insulin pumps and very concentrated insulin, so those that could also be implanted, and this idea of having a sort of very different way of managing the condition for diabetics, etc. As you can imagine, if you have things like continuous glucose monitors embedded under your skin, there's an enormous amount of data on an almost constant basis being produced in relation to your basic, your medical basics, etc., your vitals, as we might say. So this idea of, the use of data, there's nothing new about this. It's not a new phenomenon. What is new, I think, is the volume of data and what people do with it. So if we look and move on, sorry, there is a little bit of a lag here, my apologies. What's been the framework? How have we looked at these cases so far under the competition law structure? So the cases initially basically treated data more or less as an input. So it's a little bit the same mindset of the way that we look at, for example, patents, and a very similar test. It was essentially what, the Bronner test, which is a test for IP. And so they look at it, even in, for example, multi-sided markets, where you might have, for example, one side of the market where it is quote unquote free to the user and it's monetized by the use of the data on the other side, i.e. advertising. That type of model is fairly commonly looked at, and the data is viewed as being an input. The first of the cases that was sort of moved beyond that, I think, was Microsoft LinkedIn, and that case was about machine learning, where you actually use the data for the software itself, for the actual product, in that case CRM products, to learn, to improve. And that was the first time the Commission considered something that was slightly different from this sort of advertising, free versus cross-subsidized model. So if we look at sort of the framework that has been used, most of the focus is on data collection and its use then as an input. There hasn't been a huge amount of assessment of the type of data. So, is it the data itself, or is there a scale effect? So is it essentially the sheer fact that you're collecting so much data, or is it the actual particular nature of the data itself? There's another issue that is starting to come up and becomes particularly difficult, I think, which is the third point on this slide, which is that data can be used in multiple markets and can and often is used subsequently, particularly in the merger context. If you think about acquiring an entity X number of years down the line, you might come up with new and different things to do with the data that people genuinely weren't even contemplating at the time they did the transaction. So part of the difficulty with these things is because data can be used in so many different ways. It makes it particularly difficult to do a forward-looking merger assessment when you think about the 3 to 5 year time frame we use. So that's the sort of the basic underlying analytical framework. The sort of the theories of harm that have been used, as I mentioned, the initial cases thought about this idea of exclusion. So this is the Bronner test. Is it possible that by having or acquiring this data set, or the potential to gather that data, that you will somehow also have acquired the ability to exclude others? And so the analysis that has been done in those cases has kind of followed this test of, that comes from the Bronner framework. So basically replicability, exclusivity, i.e., are you the only one who has access to it? The degree to which the data is important in terms of the ability to be able to compete in a downstream market. Are there decreasing returns on the data, which is quite closely linked to the next point below that, which is, does it very quickly become stale and dated? Is it data that is actually only useful to you sort of in the here and now? So think, for example, about locational data. Depending on what you're doing with it, it might only be useful if you're going to use it to send me a special offer on a coffee from a coffee shop as I walk by. That's useful to you in the here and now. It may be useful to someone else in the future when they want to have a look at how often I walk particular routes, and whether there might be ways of trying to entice me to walk a different way to pass a different shop, for example. But there's a timeliness difference between the utility of the data in those two scenarios, just to illustrate for you. So that it's that sort of framework that has been looked at so far. There's been some consideration about whether it's the data itself, or is it the fact that you can use the data to draw insights? So, for example, my point about, this is clearly my route to work because, I walk it every morning at 7:30 and I stop at this coffee shop, etc., etc. That's an insight that could be used to try and encourage me to walk somewhere else and go to a different coffee shop, for example. It's not the actual fact that I was on the street at that particular time that is relevant to you. So these cases have looked at that idea of exclusion. They've looked at timeliness. They've looked at the different theories of harm. They've looked at the idea or the question of whether concentration is likely to enhance a position in an existing market. That's quite unusual. So the two data sets, somehow enhancing position. I think the best example of that we've had so far is TomTom TeleAtlas, which was that sort of the online mapping thing where you actually had two providers of those types of mapping resources merging. In most cases, that's not the situation. It's more the second point on this slide, which is the idea of augmentation and accumulation of data. So, what does it do to incentives to collect more? What alternatives do third parties have? This comes back to the idea of exclusion, which if we go to the next slide, just give me a sec while it catches up. You've got this idea of exclusive access to data. So you've got sort of different approaches here. You've got, if you are the only person who has access to that data, can you somehow use it to either raise your rival's costs or to disadvantage rivals because they don't have access to it, such that they either can't expand or enter? And so this has been considered in a couple of instances. It was looked at back in Facebook WhatsApp, where the idea was, getting hold of the WhatsApp data, was that somehow potentially going to enable Facebook to do something with that data that others would then be unable to do in the marketplace. Again, in Microsoft LinkedIn, they tested that and got a resounding response from the market at the time that the LinkedIn data was not going to make anything like the difference to the CRM software that was being tested when the commission went out to the market to ask the questions. So it is important to actually test whether or not the data is important. The resounding response in Microsoft LinkedIn, it's all over the footnotes in the case, says, the Oracle and SAP, who were the much bigger players in that space, had come back at the time and effectively said to the commission, we don't have access to this today, we don't need it, and it's not particularly competitively relevant in our view. And that's, that's a very different response to, I think, the one the commission was expecting to hear. Network effects is also an issue that's been looked at a lot in the context of whether, once you effectively create this reinforcement, this cycle of gathering the data, when, having gotten that much data, do you then create a feedback loop that means that you keep effectively exponentially gathering more and more that others can't catch you with? So that was looked at a number of times, Facebook WhatsApp again, but even earlier back in Google DoubleClick, when Google put together the first deal that enabled Google to put together the two sides of advertising there. And then, of course, you look at things like the cross-platform network effects. That was considered and dismissed in Apple Shazam. So as you can see, there's a lot of cases where these theories of harm have been looked at through the competition lens and have effectively been found not, in most of the cases, not to actually be a concern. Which leads me to this current slide, which is essentially the elements of these cases that warrant some, if you like, caution in the context of just assuming that access to data or an inability to access data necessarily causes harm. And I think that's one of the key things to think about in the context of regulation that's being proposed, that is essentially, not all data is equal in some senses, depending on what it is. You need more or less of it. It ages or it becomes stale at different rates, all those types of issues. There either are or there are not alternative or fungible data sets that people have ready access to. So I think it's important that, and the cases draw this out, which is why I spent a bit of time talking about them, that we can't just talk about data and assume that all data sets in all contexts will necessarily create comparable or equally serious issues. There's a significant challenge here of basically looking at, the breadth, looking at how fast some of these markets evolve, such that, for example, access to data that might be an issue today may be completely irrelevant when a new data source comes to light from a new service that doesn't even exist today, for example, in the next, X number of years. And then there's that fundamental question, which is at the very bottom of this slide, which is it the data actually improving the product itself? So is the data being used to improve the quality of the service that is provided to the users? And I think we are yet to properly unpack and think through the implications of the difference between monetization of data in some way, shape, or form, and actually using data, whether it's through machine learning, as was thought about in the context of Microsoft LinkedIn, but in other contexts as well, to actually improve the quality of a service. For example, to tweak and improve algorithms, whether that in and of itself is the same or something that should be dealt with differently in the regulatory environment surrounding the use of that particular set of data. And so there's a separate set, if you like, of theories of harm that have been started to be explored in the context of algorithms. Because as I say, I think there is, and it is appropriate, fully appropriate, to look at the use of data in the context of algorithms somewhat differently, because you're then effectively looking at and you're weighing up the pros and cons of enabling product or service improvement itself through the use of that data. And you then get into a whole series of different questions. In my view, the difference between improving an algorithm or improving the quote-unquote platform, to Florence's point, versus in some way, shape, or form competing, whether it be through advertising. When I say competing, I mean competing with people who might be using the platform, whether it be through advertising or some other way, that we need to think, I think, long and hard about the distinctions between those two different types of use of data. So this, for example, if you like, pulls out the way the Commission went through the elements of, okay, what happens if you are using the data for machine learning? So this is essentially the thought process that they articulated in Microsoft LinkedIn. And you can basically see that they've gone through and they've looked at, who else has access? Can you restrict access? Would somehow the exclusive access to that data, would that somehow affect an important portion of the service competitors that you might face in the space where you're actually using the algorithm that's been improved? So they've gone through and set out, if you like, a very different thought process from the one that is set out earlier in the slides in relation to things like effectively multi-sided markets, where you're effectively funding one side of the market through the use of data through advertising. Again, slight delay, apologies. Okay, and then you can see sort of some of that, as I mentioned, was considered in the Microsoft LinkedIn decision, where they looked at basically the CRM competitors, which I briefly touched on. They looked at whether or not, for example, the APIs were made available that would somehow potentially impair the ability of third parties to get access to certain other types of data. They also looked at in the Google comparison shopping case. So again, this is behavioral rather than a merger case. They looked at the importance of query volumes. So particularly in that context, the tail queries. So in other words, the less common queries, where a search engine that gets less volume learns more slowly about breaking news. I'm paraphrasing, but that's the sort of the general gist of it. And then they also, however, made an interesting point there about the diminishing returns to scale in terms of the improvement. So there is this very real question, which at least I'm sure some of the engineers, including Paola, can speak to, but at least conversations I've had with clients, that the size of the data sets that you need, for example, for machine learning, are actually much smaller than you might expect. And that actually teaching the algorithm or allowing the algorithms to teach themselves doesn't require anything like the volume that intuitively one might anticipate it does. And then there's another couple of theories of harm that are being considered in the context of algorithms. I've put these up here for completeness. Again, I don't think they're particularly relevant for the discussion today, but as I say, I've put various slides into this presentation just so that kind of all of the relevant pieces are there. It's not something that I particularly think we need to spend a lot of time on. These are, the theories of harm about things, for example, use tacit collusion, so basically price alignment. So we've got a UK case, a CMA case on the posters there, where basically a couple of poster sellers who were selling through Amazon. To be clear, it wasn't Amazon doing the selling, it was the third party selling through Amazon, who were offline, so not using Amazon to do it, but offline, effectively engaging in good old-fashioned price setting. So there was some discussion, however, in that case about whether or not algorithms could be used to do the same thing. So whether it could provide a mechanism for tacit collusion. And then there are other things you may have seen in the press in the last few days because of some of the coverage of the DOJ's case against Google, that this idea of co-opetition, I think, has made it into the mainstream press in the last few days because of the particularly Apple-Google arrangement with search. And so, there's a question being asked, as a potential theory of harm, of whether algorithms may need new forms of anti-competitive behavior, where you've effectively gotten entities that have, if you like, similar interests in it, capturing and extracting and using the data across different players. And then the third piece is the potential for a design feature, essentially to be deception for consumers. So those, as I say, are very particular, and I don't think are related so much to data in the context we're thinking of. This is more sort of old-fashioned price setting and otherwise anti-competitive collusion between potential or actual competitors. So then I've got 4 or 5 slides, and again, I didn't realize this was going to be quite so slow. So I'm just going to keep talking as I flick through the slides. I've just put in literally 4 or 5 slides that give you the cases that I've kind of name checked as we went through. So essentially we've got the mobile wallet case, then we have Facebook, WhatsApp, and then we have a couple of slides trying to summarize what was looked at about data, to be clear, in the context of Microsoft LinkedIn as well. I'm not intending to speak to them, but again, as I said, I wanted to make sure that the deck is relatively complete if you want to go back and have a look at it. But this is what I did want to talk about, which is, okay, so where might we be going if we're looking forward on the competition side? So, where you've all kind of seen and heard the things that have been said in the last, particularly, I would say, 4 or 5 months, as the agencies were leading up to the digital services or digital markets, depending on what it's called today, Act, the new competition tool, and various other things. And so I think the key kind of thing to think of here is it's about data accumulation. I think the idea that the accumulation of data needs to somehow enable the exclusion of others is being refined or modified, might be the best word to use there, by the agencies at the moment. If you look, for example, at the second bullet here, where we've got the quote from Commissioner Vestager, where she says, is access to data one of the things that would allow rivals to do better and be much more relevant for the people that they do business with? So in other words, is the sheer fact that one entity is able to accumulate data and others are not, is that in and of itself something that competition law should be looking at? And if you look at these quotes on the next slide, I think you get a fairly good sense of the direction of travel, with the first one essentially dating to March 2019, then we jump forward to February of this year, and then in the context of Google Fitbit, the public statements from the commissioner in August of this year, you can see this idea of data accumulation. So, data accumulation in the hands of a single firm may raise competition concerns. Potential for degradation in data protection may result in harm to competition that can be addressed by competition law. Data accumulation, data protection have already taken into account in certain cases, etc. So that was 18 months ago. Then we jump forward to February of this year, and the Commissioner, the European Strategy for Data sets out the statement that the EC will look closely at the possible effect on competition of large-scale data accumulation through acquisitions and at the utility of data access or data sharing remedies to resolve concerns. So you can see the idea that the accumulation and that it's exclusive access to that data and that it's somehow the ability to exclude others has gone. All of those elements are now gone out of the discussion in the public domain. So we don't have to go back very far. I gave you the cases where, you know, those things are all there. It's gone now. What we're talking about is just the data accumulation. And if you look at August of this year, which was sort of early on in the Google Fitbit investigation, the use of wearable devices is expected to grow significantly, et cetera, go hand in hand with an exponential growth of data generated through those devices. This data provides key insights about life and health situation of the user. Our investigation aims to ensure that control by Google over the data collected as a result of the transaction does not distort competition. Again, just merely a reference to the control. It's not what they're going to do with it, but it's their control over it. So there's been a shift. If you look at these recent statements, going back to the older cases, that there is a definite view that the accumulation of data in and of itself is potentially something that competition law, let alone regulation, should look at. Which brings us to the regulatory layer, and I'm conscious of time here. I've called it building momentum, but what I've done is a quick reminder here. Again, I'm not going to go through each of them, but just if we think about the way these reports have effectively built on each other, or the conclusions from them and the drumbeat about accumulation of data has built. So if you go back to the report on competition policy for the digital era and the Chatham House event that DG Comp hosted back in January of 2019, and you look at, you know, the idea of market power, you look at the interoperability and data access. Those of you who were in the room will remember that there was various discussions, and this has been in the public domain since, various discussions where effectively data was described by a number of people as a quote-unquote essential facility. And so that was, if you like, the sort of the beginning of this shift of the idea of just having the data is something that in and of itself raises concerns and that may need a quote-unquote access remedy to address. After that report, we also have the UK report, so the one that is commonly known as the Furman report. That has led to things like the creation of a distinct unit, which is now inside the CMA, not Ofcom. There was also, been various suggestions there about requirements to notify, etc. But again, this kind of drumbeat, the very last bullet on the page is about data interoperability and data access. So there is, again, coming from almost simultaneously from the different angle of the UK team that looked at this, a similar review. In the context, sorry, I was a little bit too quick there. In the context of the Cairncross report, which is one that slightly followed the Furman report in terms of chronologic, timing at least. And in that context, and this I think is something that Paola's going to pick up when she speaks shortly, part of the point there that was being made was the imbalance between the platforms and publishers. So the idea that the platforms, this is clearly the context of advertising, obviously, that the idea that there is an imbalance and that the publishers and the platforms have different degrees of control and access to data, and the implications that has for competition was first raised, at least in Europe, in the Cairncross report, followed more recently by the CMA's online platforms and digital advertising investigation, where the final report has just come out this summer. And they've effectively concluded that the potential range of issues is so broad that there needs to be a new digital markets unit that essentially, in addition to being able to enforce a code of conduct, that can address market power and increase competition. And you can see in there that it talks about increasing interoperability and providing access to data. So I'm starting to sound like a broken record. I appreciate that. But the point I'm trying to make is that there is this drumbeat of the idea of interoperability and access to data that has come out of these cases, out of these reports, I should say, with, I would also say, very limited support from the existing case law for it. Which leads us to the regulatory layer. So the interim step, if you like, and I want to make sure I leave Pal at time, so I'm just going to touch very briefly on the regulatory layer here in the form of the platform to business, or P2B regulation, where essentially this did not go. It did not touch the ideas of access to data or interoperability. It's all about transparency. It's all about transparency. It's about, arguably, at least its recitals talk about fairness, and they're talking about fairness in the context of the relationship between platforms and businesses who use that platform, and then dispute resolution, redress mechanisms, essentially. So the scope of the P2B regulation does not touch these issues about access to data and interoperability. It's effectively an attempt, my personal view is not entirely successful, but it's an attempt to try and, if you like, provide some degree of additional information to businesses which may or may not have already been able to access it, depending on the platform you're talking about. And frankly, I think that's one of the biggest difficulties with the regulation, that it is so broad in its ambit that the application of it to different things, as in different platforms, different businesses, different contexts of the relationship between the platform businesses, the business, and quite frankly, the consumers or customers on the other side. There's a huge range of things that are all pulled into the scope of the regulation. There are some things in here that start to edge in the direction of data, in the sense of, for example, the ranking requirements, where there are these obligations to basically make clear in the terms and conditions the main parameters that are being used, for example, by an intermediary, and to describe the potential to influence ranking through remuneration. Again, I think we understand what the European institutions were trying to get at here. It's just a very difficult line to walk, I think, in some contexts, to understand, for example, what exactly is a main parameter and how much transparency do you need to provide in the context where, for example, you want to make sure that people don't game an algorithm. So striking the balance and finding the appropriate line there is, I think, a little more challenging than may have been understood in the first instance when it was drafted. And there's another side that talks about some of the other elements here of P2B, things like differentiated treatment, ancillary services. So, for example, if someone offers insurance alongside another product, can businesses using that same platform also offer insurance, and on what terms? The final thing I want to talk about before I hand over to Paola is the public domain material, i.e. what has been said by agencies, what we can glean from, reading our crystal balls and glean from the various sort of leaks that have made their way into the press, etc., of what is in the either Digital Services Act or Digital Markets Act, depending on which versions of which leaked document you've read stories about. So it's clearly still a work in progress. It's clearly still something that I would imagine is subject to a great deal of change. It does seem that there is an appetite or a view that we go back to, the bad old days with block exemptions, that kind of structure that we all knew and loved, of having blacklists, whitelists, and grey lists of provisions that are, good, bad, and then somewhere, I guess the one in the middle is the ugly, I'm not sure, where, that certain types of conduct are classified in particular ways. There are, if you like, data, I would say, is front and center to the whole discussion around this. So if you think about the things that are being debated and heavily lobbied, the use of data by gatekeepers, that I think is issue number one. Then you've got, access by business users to data and the use they can or can't make of it. Now, the question is whose data and how do you determine whose data it is and on what terms, is access granted? Is it to only the particular business user? Is it to everybody? Those broader types of issues that come out of this access by business users question. Then there's, of course, the derivative of that, which is at least as hotly debated, which is the access by business users to the gatekeeper data. So in other words, if hundreds, thousands of business users provide information to the quote unquote gatekeeper, then do all of those business users have some sort of entitlement to presumably aggregated, but data that comes out of what the gatekeeper does with the data provided to them? So that's sort of the second issue that's being debated in this context. Then, of course, kind of logical sort of third step from those first two is the idea of combining data. So whether it be your own data from, for example, different businesses, data that, for example, might come from both a gatekeeper and a business user, or data that might come from a third party altogether. As we mentioned right back at the beginning, certain types of data have been available for purchase for many, many years. So there's sort of all that cumulative kind of set of questions about what data, who gets access to it, and what are you allowed to do with it, that is currently under debate here. And then, of course, just for completeness on the data point, data portability and interoperability. So again, this is those same access to data and interoperability points that was coming through loud and clear from those reports. And the final point I will flag on this slide is similarly to that, sort of the drumbeat point is the self-preferencing. So there are various forms of self-preferencing that are also under discussion that in many cases revolve around, but don't involve, at least yet, a suggestion of providing access to data. So they revolve around data. So for example, displaying and ranking on an intermediary or a quote unquote by a gatekeeper. The idea, various other ideas about exclusive pre-installation. Some of this I think is being driven by the act that's under or the legislation that's under consideration, and the Internet of Things sector inquiry that has just been kicked off, where people were responding 10 days or so ago to some very, very extensive RFIs. The idea of anti-steering and side-loading provisions. So you can see there's this idea of preferencing is also in some part being driven by the idea of data or access to data in particular, and who gets access and to what do they get access. And at that point I will stop so that Paola can get much more concrete for you.
Thank you very much. I think it was very, very interesting presentation on all these competition law aspects, and you really showed how we shifted from advertising issues, and then we shifted the cases to more the digital world and questions of algorithm and so on, which are currently very discussed. We see this trend, this evolution. I don't know how you would explain this evolution from this shift from cases. Would you see it more because that's a question of opportunity for the digital industry, digital platforms, and the big digital players, that they simply try to find new ways to overcome the law, or is it an evolution of the technology which explains why there is this shift from in the cases? What would be your view on that?
Yeah, I'm not sure. I'm not sure it's anyone trying to sort of overcome or evade the law. I think part of it is driven by technology. So, the idea that for example, the commission would have been investigating theories of harm like the ones it looked at in either Apple Shazam or Microsoft LinkedIn. The idea that they'd have even considered that 10 years ago, they'd have looked at you like you had two heads, I think, if someone had put that theory of harm on the table to them. Because that back then, the idea that there is, that an individual, if you think about Apple Shazam, right, they were trying to understand whether the playlists would in some way, shape or form, confer an advantage on Apple. I think at the time when they started, they hadn't realized that Shazam was the one who proposes the playlist to the users, not the other way around. And so, that sort of idea that you'd have the technology in basically a music streaming service that clearly what they had in mind was that, and it exists, that it's smart enough, might not be the right word, but the technology is there to actually look at your habits, look at what you listen to, and then the algorithm goes through and says, so this would be a good playlist for you. That technology didn't used to exist. And so there's kind of that level, and then there's the thinking that has evolved, I think, quite significantly, which is, go back 5-6 years, it was about, okay, if you had that data, could you exclude someone else? Could you somehow impair the ability of someone else to compete? We've moved beyond that now, and we're now in a situation, I think, where, at least from the public statements from the commission, where they're just going to say, okay, but if you have that data, can you effectively then outpace everybody else in such a way that they are unable to compete with you? That is a mind shift, I think, by the agencies that is not driven by technology per se.
But where do you think the future case is going? What kind of cases we'll see, in your view, in the future?
I think we're going to see more and more cases that look at sort of almost what we call, competition lawyers call, conglomerate effects. So the idea of a data that can actually somehow affect a huge number of other markets. And the challenge with that sort of thing, that type of analysis, is, as I said earlier, you need a particularly clear crystal ball to be able to anticipate all of the potential markets where something could be used, because otherwise it's just, you're effectively shadow boxing. You're effectively trying to say that, in a hypothetical undefined market, having, the only people with a particular data set can't raise competition issues. That's a very difficult argument to have to make, extremely difficult